Protections against employment discrimination based on sexual orientation or gender identity. On June 15, 2020, the Supreme Court of the United States issued its landmark decision, which held that the prohibition against sex discrimination in Title VII of the Civil Rights Act of 1964 includes employment discrimination against an individual on the basis of sexual orientation or transgender status. What kind of discriminatory employment actions does Title VII prohibit? Title VII includes a broad range of protections. Among other things, under Title VII, employers cannot discriminate against individuals based on sexual orientation or gender identity with respect to hiring, firing, furloughs or reductions in force, promotions, demotions, discipline, training, work assignments, pay, overtime, or other compensation, fringe benefits, other terms, conditions, and privileges of employment. Discrimination also includes severe or pervasive harassment.
You're transgender. You were a man last month. You can't go into the women's bathroom.
It is unlawful for an employer to create or tolerate such harassment based on sexual orientation or gender identity. Further, if an employee reports such harassment by a customer or client, the employer must take steps to stop the harassment and prevent it from happening again. Are non-LGBTQ+ job applicants and employees also protected against sexual orientation and gender identity discrimination? Yes, employers are not allowed to discriminate against job applicants or employees because the applicants or employees are, for example, straight or cisgender, someone whose gender identity corresponds with the sex assigned at birth. Title VII prohibits harassment and other forms of discrimination based on sexual orientation or gender identity. Could an employer's discriminatory action be justified by customer or client preferences? No. As a general matter, an employer covered by Title VII is not allowed to fire, refuse to hire, or take assignments away from someone, or discriminate in any other way, because customers or clients would prefer to work with people who have a different sexual orientation or gender identity. Employers also are not allowed to segregate employees based on actual or perceived customer preferences. For example, it would be discriminatory to keep LGBTQ+ employees out of public-facing positions or to direct these employees towards certain stores or geographic areas.
You're gay, so you'll be working from now on in our location in the gay part of town.
Is an employer allowed to discriminate against an employee because the employer believes the employee acts or appears in ways that do not conform to stereotypes about the way men or women are expected to behave? No. Whether or not an employer knows an employee's sexual orientation or gender identity, employers are not allowed to discriminate against an employee because that employee does not conform to a sex-based stereotype about feminine or masculine behavior. For example, employers are not allowed to discriminate against men whom they perceive to act or appear in stereotypically feminine ways, or against women whom they perceive to act or appear in stereotypically masculine ways. May a covered employer require a transgender employee to dress in accordance with the employee's sex assigned at birth? No. Prohibiting a transgender person from dressing or presenting consistent with that person's gender identity would constitute sex discrimination. Does an employer have the right to have separate sex-segregated bathrooms, locker rooms, or showers for men and women? Yes. Courts have long recognized that employers may have separate bathrooms, locker rooms, and showers for men and women, or may choose to have unisex or single-use bathrooms, locker rooms, and showers. The Equal Employment Opportunity Commission has taken the position that employers may not deny an employee equal access to a bathroom, locker room, or shower that corresponds to the employee's gender identity. In other words, if an employer has separate bathrooms, locker rooms, or showers for men and women, all men, including transgender men, should be allowed to use the men's facilities, and all women, including transgender women, should be allowed to use the women's facilities. You can't use the women's bathroom. Last week you were a man. Could use of pronouns or names that are inconsistent with an individual's gender identity be considered harassment? Yes, in certain circumstances.
You're not a real woman. I will never refer to you as she or her.
Unlawful harassment includes unwelcome conduct that is based on gender identity. To be unlawful, the conduct must be severe or pervasive when considered together with all other unwelcome conduct based on the individual's sex, including gender identity, thereby creating a work environment that a reasonable person would consider intimidating, hostile, or offensive.